between those who cause loss and those who don't, and that there is a need to strike an appropriate balance between tort rights and first-party benefits. It doesn't matter whether we agree on the outcome in Morrow or any of the judicial interpretations of the law in Ontario. What matters is that we need reforms that don't bring us back to the table every 5 years. We can't come back again 5 years from now because we didn't get it right. And we need reforms that smooth out the return on equity cycles that the industry is subject to and provides consistent pricing to the public. We know that uncertainty or volatility creates problems in managing the business of insurance. And we know that precipitous premium increases must become a thing of the past. Tort limits never have and never will bring stability to auto insurance. We know that the 2003 reforms completely failed to address what was wrong with auto, and that's why we're back in 2008 talking about either double-digit increases in premiums or reform to the product. My suggestion is that we craft a lasting solution that insulates the public from precipitous premium increases, that recognizes the appropriate principles associated with tort rights, and reforms that restore the insurance industry to sustained and predictable profitability. Thank you.
Thank you, Richard. Thank you very much. Now we're going to go to our first question. And it goes. Now there are different views as to whether a problem really existed regarding auto insurance that required governments to make the tort reforms they made, whether through general damages caps for minor injuries or deductibles on general damages or thresholds for suing for general damages or some combination of these. Can I ask you to comment? Richard first, please.
In the mid-1980s, the former Associate Chief Justice Coulter Osborne had a commission on auto insurance and delivered a report, and it's as relevant today as it was back then in the mid-1980s. It was really, I thought, a brilliant work. I want to just go back, though, to recent history, which is 2003, and talk about the increase in the deductible and the threshold regulation that toughened the threshold in 2003. And I want to make 2 points about that. The first is that there was no economic justification, in my view, for the changes in 2003. And the second is that the attempts to limit tort in 2003 were not an appropriate response to what was happening with the industry in 2003. We know, just on the economic side, we know that between 1999 and 2002, that ROE fell to unacceptable levels for the insurance industry. That's a fact. The reason that happened, I think, is a matter of debate, but we know that pricing certainly didn't keep pace with claims costs. We also know that, at least retrospectively, that without the changes in 2003, the industry would have enjoyed a recovery quite apart from those changes. 2003 turned out to be the biggest year in the history of the P&C industry in terms of profitability. 2004 was an enormous year. Now, I know I haven't isolated, I know the argument, I haven't isolated Ontario Auto, and we have to talk about Ontario Auto. But I think that everybody in this room will agree that 2004 was the biggest year in the history of Ontario Auto in terms of return on equity and profit. We do know that claims costs have followed historically consistent patterns, a linear pattern, a climbing linear pattern, and that, in my respectful view, claims costs have always been predictable. From 1996, if you chart claims costs from 1996 until today, you'll see a linear pattern, albeit it increasing, but a linear pattern. We also know that returns on investments for insurers over that same period of time have also followed a linear pattern, albeit a downward linear pattern, but nevertheless a linear pattern. What we see, and the only variable that doesn't seem to follow a linear pattern, is return on equity and profitability, and that goes in cycles. The problem with what happened in 2003 is obviously we were in a trough. We were in that cycle, that down cycle, and I think that we reacted prematurely to what was happening then because the industry truly was on its way back up. in terms of profitability. And the fact that we know since then that the industry has done, at least for 4 years since then, extremely well on auto, I think proves that, especially since the cases that are affected by the increased deductible and by the threshold have not yet made their way through the system. We have really only one threshold decision to look at since 2003. Another one came out last week, but I don't think it's that meaningful. And the one that came out a few months ago in London, I think most of us would agree was poorly reasoned. But having said that, the only variable is these swings in profitability. And when we get to that trough, the objection I have about what happened in 2003 is that you look to the government to lower costs by reforming the product. And I think the problem in 2003 wasn't a problem of claims costs. In fact, I know it wasn't a problem of claims costs. The problem in 2003 was a problem of pricing. Now, part of it, I think, we can be critical about the industry about, in part we can't. We know that the rate approval process, things lag and it's expensive. But the problem was pricing. Where you allow your margins to disappear in a soft market and find yourself in a bind because ROEs have hit rock bottom, the response with respect is not to seek changes legislatively to lower your costs, but to do it internally, which I think was being done anyway because we know that you popped out of it in 2003 without the changes. So the other thing I want to say about what happened in 2003 is that given developments since 2003 and the fact that we find ourselves today looking for double-digit increases in premiums again, illustrates that tort limiting rules are not the way to address what's wrong with the industry. What we have to look for are those changes that aren't vulnerable, that those changes that provide sustained and lasting stability to the product for consumers and for insurers. So I think it's an issue primarily of pricing and not costs, although costs are an issue when it comes to first-party benefits. I think we'll talk about that a little later. So that's sort of my take on that.
So I guess the converse of that is to look at what happened in Alberta before the reforms and after. I think the one thing that everyone agreed to in the Alberta cap case is that there was a crisis in the auto industry prior to the reforms. There were problems with affordability, accessibility to automobile insurance, rising claim costs, and the inability to get people back to their jobs and their working lives because Schedule B benefits weren't being used. Just to throw some numbers at this, in 0203, premiums in Alberta had risen respectively 16% and 15%. Over 11% of young drivers had to find insurance through the Facility Association, and in many cases, their premiums for young drivers was in the $7,000 to $10,000 a year, which of course led to the next problem, which was prior to the reforms, the estimate was that over 10,000 Albertans were driving without insurance, and claims under the Motor Vehicle Accident Claims Fund for uninsured motorists had increased 18%. The evidence at the Morrow trial that came out from all the experts was that between 86 and 04, bodily injury liability claims accounted for 88% of the total increase in claim costs, that 48% of the compensation of third-party liability claims consisted of non-pecuniary damages, which is where the cap was, and that figure rose to 84% for claims under $10,000. In reports to the government in 2002 and 2003, the rate board held that injury claims remain the root cause of the escalation of third-party liability premiums, and they say that they were spiraling out of control, and that in a memo to the minister in 2002, it's warned that the building pressure for premium increases could lead to a significant public backlash. In 2002, the loss ratio for third-party liability coverage in Alberta's private passenger vehicle market stood at 91% after 4 consecutive years of being 100% or higher. And finally, in this period up to 2002, bodily injury claims cost per vehicle had more than tripled, while property damage costs had grown by about 33%. So in the face of all that, you had a premier who was running on a platform of either freezing rates or lowering rates, and in fact imposed a law in 2003 that rates had to be frozen, as many of you know. And you have to sort of compare what happened post-reforms in the studies that they looked at during the trial, was that 2/3 of the people who were going to the facility association were no longer going there. The amount of uninsured motorists had dropped dramatically. Premiums had decreased by approximately 15% across the board. And the evidence was that the protocols that were brought in to help in terms of Schedule B benefits were actually working and getting people back to work quicker, back to their work and their daily lives quicker. There's a whole bunch of other statistics and evidence that was heard in that trial about the costs which led to the reforms. Time won't permit me to go through it, but if anyone's interested, I think the affidavit of Superintendent Gartner is publicly available, and it goes through the whole story of how they had to deal with this crisis.
Well, if I can just address that.
2-minute rebuttal time for you, Richard.
Thank you, Randy. The Alberta decision has little meaning in Ontario, and I think the mistake that the plaintiffs' lawyers made in the Alberta decision is that they failed to capitalize Ontario's experience with tort-limiting rules. The fact is that in Ontario, we've been through 4 different regimes, starting with the 1990 OMPP, where we had severe threshold. We went into 1994, Bill 164, and what was a disastrous system of very limited rights for general damages and enormous first-party benefits. 1996, we restored a threshold and a deductible and allowed some lawsuits for economic loss. And then in 2003, it changed once again. The point that I want to make is that each of these changes that we have made has not solved the problem for either the industry or the consumer. The problem isn't solved. We're back in 2008 when change is desperately needed again to the insurance product. We know we can't increase premiums by double-digit numbers. So Alberta isn't an example for Ontario, and I think that the plaintiffs' lawyers in Alberta made a mistake by not focusing a little more on and benefiting from the Ontario experience. I think the fact is that if there were inflationary increases, gradual inflationary increases, or even slightly greater than inflationary increases in premiums over time, there would not be public uproar about what's happening with their premiums. Just like the bag of groceries that people buy at the grocery store, or their incomes go up, so too will the public tolerate inflationary increases in premiums, or slightly better than inflationary increases in premiums. We've done polling through Ipsos Reid that confirms that. The other point I want to make, I know I'm going over my time very quickly, the other point I want to make about Alberta is that the judge observed in Alberta that there are other ways to achieve the savings other than off the backs of innocent accident victims. And what I'll say to that is that while he didn't express in his opinion what those were, there are ways to achieve it.
Thank you, Richard. Your second question is that the general damages capped imposed on those suffering minor injuries has come under attack for not being in compliance with the Charter of Rights and Freedoms. Alan mentioned that already. And I'll ask Alan to elaborate on his views on that.
Okay. Well, I guess what I can do in the time we have is I'll just touch upon some of the arguments we made in the Alberta cap case to overturn the trial judge's decision. I should probably comment on one thing Richard has said, which was sort of the mantra of the plaintiffs' counsel, both at the trial and at the appeal level. They kept saying, well, you can, if there's a crisis and you're trying to get rates down, et cetera, you can do all this, but don't do it on the backs of this historically disadvantaged group. And in my view, that was really just a way of characterizing what happened in a very biased way, because the reality is, if you look at the entire reform package, there were a lot of benefits that went into the package, including for people who had these very types of injuries to get them back to work quicker, to increase their Schedule B benefits, et cetera, et cetera. And to people in the industry as a whole. Drivers, rates went down, uninsured motorists went down. They took away all the so-called discriminatory factors in rate filings, such as age and sex and marital status. So, one of the goals of the legislation was to eliminate discrimination. So it's rather ironic that they ended up being challenged for being discriminatory. But let me just, we don't have a lot of time, but I'll just very quickly give you a sense of the arguments that we made and that the Crown made on the appeal to overturn the decision of Justice Whitman. The first was what I'll call, there's no free lunch in the insurance industry, which, again, I thought I should be a bit more articulate than that, which was that, when you look at these reforms, you had to get those cost savings somewhere, and you have to look at the reforms as a package. And we said that the trial judge focused way too much on just the cap and not what the benefits were under this legislation. And in doing so, he took a very one-sided view of the problem, and he sort of ignored the fact that there were all these benefits and that these benefits accrued to the very people who were challenging the legislation. We argued that the fact that everyone gets individually assessed once you've been in an injury to determine whether or not you are above the cap or below the cap or what kind of treatment you should be getting right off the fact is counter to the idea of discrimination. If you're being individually assessed on your merits, i.e. your injuries, that is completely counterintuitive to what the Supreme Court of Canada has consistently said what discrimination is. Discrimination is the idea of being prejudged or stereotyped, not based on who you are. So we emphasized that point. We said that the group that Justice Whitman compared the soft tissue injury people to, because when you're in a discrimination analysis, you've got to compare the group to another group and see if they've been treated unfairly. The group that he compared them to was anyone who's ever been injured in an accident. So that would include people who, have life-threatening injuries or quadriplegics. And we said, no. You've got the wrong comparator group. You've got to compare them to a group which are most closely aligned to their characteristics. And the group that was most closely aligned to this group's characteristics are soft tissue injury claimants above the cap, so people who have a serious impairment. And once you make that comparison, what flows from that is that all this is a distinction based on severity of injury, which is what courts and tribunals do every day. It's not discriminatory. The other thing that flows from that is you reach the inevitable conclusion that these people do not have immutable personal characteristics that they can't change, because they're either going to get better, in which case they're no longer injured, or they're going to get worse, in which case they're above the cap and they're not going to be subject to the cap. So we say that he got the comparator group wrong. We argued that Justice Whitman completely missed what the Supreme Court of Canada said about temporary disabilities. So the Supreme Court of Canada has said you could, in theory, have a temporary disability which meets the definition of Section 15 physical disability. But in order to do that, you've got to look at the person's temporary disability and match it up to the government's response. How did the government respond to this? And the example I gave when I argued the case was, for example, if you had a government pension plan which you have to pay into for your whole life, and you've been paying into it for 30 years, and you come down with the flu, and you're sick for 2 weeks, and there's a provision in the legislation that says if you're away from work for 2 weeks, you lose your entire benefit. Well, arguably, that's what the Supreme Court of Canada was talking about, where your temporary disability and the government response is so extreme to take away your benefit that maybe you're protected under Section 15. But if you look at the group we're talking about, they're either temporarily disabled, in which case they're getting all these Schedule B benefits, their treatments and everything else, or they're going to recover, in which case the cap doesn't apply. So it's sort of, he just did not do that analysis at all. We argued that this group was not a historically disadvantaged group. It's not a stereotype. They haven't been stereotyped, and the evidence that was relied on was wholly deficient. We pointed out that what you're talking about here is non-pecuniary damages. This is something that in 1977, in the trilogy of cases that many of you are familiar with, the Supreme Court of Canada said non-pecuniary damages, by definition, are not compensation. They're not intended to make you whole in Canada. It is just an arbitrary amount to pay you to give you something for your pain and suffering. And keep in mind that the 3 cases in 1977 were tragic cases where people were, quadriplegics, their lives had been ruined, and the cap was $100,000. And the court said, well, we're not going to adopt the American model. This is just an arbitrary pay-you-something figure. And we said, you've got to look at that in this context of the soft tissue injuries. It's not like you're taking away their loss of income benefits or something that is, an absolute entitlement based on their loss. This is by nature an arbitrary amount. And the final argument we made in that case related to the order or the remedy that the judge made. He made an order retroactive for 3 years, which, if you think about it, really didn't make any sense on 2 grounds. One is most charter cases do not go back in time. They either stay the order and allow the legislature to fix the legislation. And secondly, in the insurance context, all of the insurers were paying their premiums on the expectation, setting their premiums, charging premiums on the expectation that the law was valid, and they were settling claims on that basis as well. So to go back 3 years was wholly unfair and inconsistent with what the Supreme Court of Canada had said about it.
Well, I'm going to be very brief because I want to invite some wooden arrows from the crowd before we use up all our time. But I will say this about the Alberta decision. First of all, this argument about the package outweighs taking away the rights. The judge essentially rejected that argument, I think, quite appropriately. But we know in Ontario that the package we have that is supposed to offset those rights, the first party benefit package, doesn't work. I mean, it's broken. It's hugely expensive. It can't be sustained. And again, I think it's a lesson that Alberta should take from Ontario, that that's not the way to do it. The other problem, of course, with the first party benefit package is that the richer it is, and Ontario has the richest, the more it pits you against your insured person. And I think that's a problem with first party benefits as well. So that's all I'll say about the charter challenge.
Thank you. Okay, at this point, I'd like to open up the floor to questions. Can we have some mics on the floor, please? When you approach the mic to ask your question, I'd ask you to first state your name, ask your question, and then tell us who you're directing the question to. See a question there?
Hello, gentlemen. I'm Tim Roth. I'm from British Columbia. I need to frame my question a bit. I've got 2 questions. I've got one for Alan and I've got one for Richard. I need to frame it a bit with contemplating the concept of historical disadvantage. Being from BC, I think just living in Ontario, you may have an historical disadvantage. That being said, you did the appeal trial in Alberta on September 12th, and I have heard no comments from that date. I reckon that no decisions have been made, and that it is not solved or settled yet in Alberta. And coming up this month in the Maritimes is more injury cap lawsuits. And I believe that the issue in the Maritimes is different than the issue in Alberta. Do you know that answer, Ellen? Number 2, I'm going to ask Richard's question so I can sit down. I spent the last 2 weeks, Richard, driving through Ontario, and I think that insurance premiums should be increased in Ontario just for safe driver courses. One of the things that the insurance company of British Columbia has done in the last 10 years, they've done an outstanding job in improving the safety of the roads in BC through different courses and plans and actions that they've invested money and time into. And one of the things that I see across the country is that the provinces that don't have that connection to the government, such as Manitoba, Saskatchewan, and BC, The insurance companies don't have a responsibility or play a large role in the safety concerns of the roads. Is there an issue here? Should the insurance companies in Ontario and other provinces be responsible for the safety, have a role in the safety of the roads and the people that are buying insurance? And should the insurance premiums reflect that? So those are my two questions.
This is still on. I mentioned John McCain's the maverick of the Senate. No, I actually do know the answer to this question. The challenge in Nova Scotia is slightly different. The issue in Nova Scotia is they have a slightly different cap on damages, and the question is there whether a physical disability is the only disability that survives the cap. And the case in issue in Nova Scotia deals with a girl who had seen her father hit by a truck and has suffered post-traumatic stress disorder as a result of it, and arguably may be excluded from the cap. So it's a slightly different argument. But what's important about the cap in the Maritimes is that, generally speaking, in the three provinces, it's an across-the-board cap. And when we argued the case in Alberta, the plaintiff's lawyer was asked by the Court of Appeal, well, what do you suggest the legislatures do? Because this is a difficult problem. And Mr. Kozak, who acted for the plaintiff, said an across-the-board cap would work because it doesn't discriminate against anyone. And I stood up in reply and said, well, it's hard to imagine that a cap that's $2,500 and applies to everybody and therefore excludes more people is a more desirable piece of legislation. And I said, secondly, for sure, somebody like Mr. Kozak, whether it's Mr. Kozak or some other plaintiff's lawyer, is going to come along and say, even though it says that it's across-the-board cap, we all know that 90% of the people being caught under the $10,000 limit are people with soft tissue injuries, so it has the effect of discriminating against them, and he's going to make the exact same arguments. And ironically, and I just pulled it, the Monday after we argued the case in the Court of Appeal, Mr. Kozak was quoted in a newspaper article as saying about the cap across the board in the Maritimes. He said, I have a number of ways of going at the across-the-board deductible, but I'm not going to play my hand right now. So I think the answer is, and I think the court was troubled with the fact that no matter how you try to do this, it's going to be open to an attack by someone who comes up with a creative argument to attack it.
I know I've been asked to respond to a different question, but just to deal with that, you need to look at the cost savings on provisions that are less vulnerable to attack before you start to look at things that are vulnerable. So we may get to that, we may not. In terms of safety, I think that every organization that's involved in injured people, car accident victims, has a responsibility to look after safety. I know the IBC has programs geared at safety. They're pretty active in what they do. The Ontario Trial Lawyers Association likewise has a Helmets on Kids program and that kind of thing where we give bicycle helmets to kids who can't afford them. So yeah, I think we all have an obligation as part of what we do in serving people who are injured in accidents to contribute to safety.
I thought I saw another question. Yes.
Yep. Ken Haig from Quebec. Question for Richard, and we discussed this briefly yesterday. I don't think anyone in Ontario would dispute that injured parties should be dealt with fairness and equity. But I'm wondering if you could elaborate on the specific recommendations that you would have that would give injured parties greater access to litigation without increasing costs and therefore premium.
Okay. Do we have another hour?